Hi, it's Adela again. I am doing this to help the people that have got a cease and desist or have had neighborhood code compliance come and do an inspection. And everybody feels like they're in limbo. They're not knowing if they're supposed to close or exactly what's happening. I just wanted to go over again what's happened to Wisdom Organics. This is a notice of violation from neighborhood code compliance. It is 12 pages long. Ultimately, the end conclusion is that there is no zone in the city of San Diego that permits medical marijuana dispensaries. So it doesn't really matter if you've done any tenant improvements, if you haven't pulled the correct permits that you were supposed to have for your dwelling. The ultimate conclusion is that there is no zone in the city of San Diego that permits medical marijuana dispensaries. So if you're one of the few that turn around and get a cease and desist from the city attorney, which I am one, cease and desist immediately. Ultimately what they're stating is that, once again, DSD has determined that a medical marijuana dispensary, also referred to as a marijuana co-op and or collective, are not a permitted use within any zone in the city of San Diego, and this use does not fit into any subcategory, which is ironic because the only way for them to, that's a de facto ban, and the way they could do that is by enacting a ban or a moratorium, like Santee or IB did, but they didn't do this. They are simply closing people down. So if anybody cares, I have a solution. We request what we call a stay. A little brief history. A stay in law is a motion to stay, is a request to temporarily stop a case or halt proceedings. Stays are typically granted or refused by a judge in charge of a legal case or by the governing legislative body. Well, check this out. The City Council is San Diego's legislative body. It is responsible for city law. So those of you who have received your NCCD's notice of violation or your cease and desist from the city attorney, all we need is 5 city council members to enact a stay. 5. So show up to city council and ask them. Tell them that you want safe access in your community. What this stay will stop from doing is they will no longer be able to issue notices of violation through NCCD using RDA funding, which I will talk about next week or soon after the holidays. And it will also stop the city attorney from issuing cease and desist letters until they have adopted a reasonable ordinance, or until they've adopted or rejected the ordinance. Our city council has the authority and the ability to do that. And if you all care enough and you want to continue to provide safe access to San Diegans, sick patients, members of your club, then show up to city council and do something about it. Ask them to enact a stay. They resume in January. Will you be there? I don't know, in case y'all are curious on how they're able to, or how they figured out that they were allowed to close clubs down. It is a well-established law that municipalities can establish zoning or other related land use regulations through their police powers. See Miller versus the Board of Public Works, 195 Cal. 477, 490, 1925. Municipalities use zoning ordinance as a method to protect the health and welfare of their communities. In instances where the state has not preempted local making authority, a city is free to regulate. The city's position is consistent with California law. In recent cases, the city of Claremont versus Cruz, 177 California Appellate 4th, 1153, 2009, the Court of Appeal confirmed that neither the Compassionate Use Act or the Medical Marijuana Program Act preempt a city's enactment of enforcement of land use, zoning, or business license laws as they apply to medical marijuana dispensaries. As such, you are currently in violation of the SDMC code, San Diego Muni Code. Violations to SDMC may be prosecuted criminally or civilly. Civil misdemeanor may subject you to penalties of $1,000 in fines or 6 months in jail per violation per day. If an action is pursued civilly, you may be subject to civil penalties up to $2,500 per violation per day and in court injunction. Additionally, if there is evidence of narcotic activity on the property, you may also be liable for maintaining a public nuisance under the General Public Nuisance Statement Civil Code Section 3479 and 3480 and the Drug Abatement Act. Damn. The Drug Abatement Statutes California Health and Safety Code Section 11570 is a specialized public nuisance statute authorizing the city attorney's office to bring an action against property owners or tenants to abate illegal drug activity on their property. If the court finds the property has been the site where illegal narcotic activity is occurring, the court may impose any or all of the following penalties against you in a drug abatement action. This is what they did to our landlord. This is why our landlord caved. The closure of the building for a maximum of 1 year pending trial. 2, damages equal to the fair market value of the building for 1 year. 3, civil penalties up to $25,000 per defendant. And 4, attorney fees and investigation costs. These public nuisance statutes authorize the city to pursue formal legal actions to fully and permanently abate public nuisance problems at the properties. The City Attorney Office of Los Angeles has been successful in enjoining several medical marijuana dispensaries from opening under the Drug Abatement Act, most recently against Organica Incorporated, a Venice Beach medical marijuana dispensary. Okay, please contact me as soon as possible if you have any questions. If you refuse to cease operating of a medical marijuana dispensary, you shall have no option but to file a complaint. I've contacted Joel Goldsmith, and they refuse to see me. They are telling me that I can get an appointment with Mary Nuesca, which I have been trying to do for months. And Mary Nuesca refuses to see me. Gabriella Brannon refuses to see me. Regarding my NOVs, what's her name? Renee Kenninger refuses to see me. Ironically, her answering machine is full, so you can't even leave her a message. And just so you know that it was also forwarded to a DART, which is a drug abatement team. I don't know, I'm not a criminal. I'm not a drug dealer. Cannabis is an herb. It is a medicinal herb. Just like this little herb here. It's called chervil. Beautiful. This is one of the many of herbs that I have in my herb garden that are extremely medicinal. And I use them for everything, for hair stimulations, for dandruff, I use stinging nettle, which grows in your yard, to stimulate the blood circulation in my feet. Everything I use. And so to single me out for another herb like cannabis is absolutely ridiculous. I see it as nothing more than discrimination and harassment. The ultimate conclusion to all of this is reclassification through the federal government. We have enough studies nowadays that can give us, we can give the federal government that show that there is medicinal properties in cannabis. Or why do you think Marinol is on the market? At $40 a pop, they definitely don't want to legalize an herb that you can grow in your yard with minimal care. So there is a bigger picture to all of this, and it's called the pharmaceutical industry. But we as people have power. It's only through a small concerned citizens that we're actually going to get this done and that things are going to happen. You need to not just show up to meetings that have cannabis in it. You know, that's important and all. But you need to show up to every city council meeting and demand that they enact a reasonable ordinance. Y'all are going to be shitting bricks if they adopt this ordinance. And everybody's going to say, how did this happen? And you're going to say, well, where the hell were you?